Good afternoon, everyone. My name is Rob Jenner. I'm with the law firm of Jenner Law in Baltimore. Welcome to our virtual town hall meeting designed to introduce people to the Child Victims Act of 2023. This is a confidential webinar sponsored by three firms: Jenner Law, Grant and Eisenhofer, and Baird, Mandalis, Brockstead, and Federico. Our three firms are working together on behalf of survivors of childhood sexual abuse. This is a confidential webinar, so your name and your identity will not be shared with other attendees. Your names have been changed when you signed into the Zoom to be attendee one, attendee two, etc. So again, this is totally confidential, and you can feel free to ask questions in the Q&A feature that we have at the bottom of the Zoom Q&A. If you have questions along the way, certainly feel free to type them in there, and we will answer them the best we can. Our goal here is to give you sufficient information to understand the Child Victims Act of 2023. What rights do you have in Maryland as a survivor, both for people who are survivors of clergy sexual abuse and those who are survivors of sexual abuse by private schools or public schools or camps, or anybody, as a matter of fact, who may have been a victim of sexual abuse by an individual perpetrator or under the eyes of an organization like the church, again, or a camp. Let me give a brief introduction of the speakers and the topics, and then we'll begin. Phil Federico of the Baird Mandalis firm will start off with a substantive review of the Child Victims Act. Steve Kelly from Grant and Eisenhofer will talk about the substantive challenges to the constitutionality of the Child Victims Act. Ray Fitch from Baird Mandalis will talk about the appellate process and the appeal from the trial court up through the appellate court system. Gordon Novod from Grant and Eisenhofer will talk about the bankruptcy process. Alicia Hawk from Jenner Law will talk about the differences between proceeding in bankruptcy versus proceeding in a trial court. And Kathy Kramer from Baird Mandalis will talk about the rights and responsibilities of a litigant, of a plaintiff in a Child Victims Act case. And then finally, Mary Beth Diaz will talk about what it's like to work with a law firm as a survivor and what it takes for communication and what the expectations are. So with those introductions, let's start with Phil Federico. Phil is one of the state's certainly premier trial lawyers and has a long history of working with survivors of childhood sexual assault. Phil's actually going to start with a short PowerPoint that we have talking about the Child Victims Act of 2023. So Phil, why don't you take it away?
Thank you, Rob. And good evening, everybody. It's very nice to be with you this evening to share this information. I know a lot of you have been reading a lot in the newspaper and probably have seen a lot with regard to, the Child Victims Act, certainly on TV, and certainly you've been bombarded with ads as well. But that information that you're getting is not complete information and doesn't really tell you everything you should know or need to know with regard to the Child Victims Act. From my perspective, the first sexual abuse case that I handled of significance was over a decade ago, and it involved a pediatrician who had sexually abused over 1,000 children in Delaware. And so working with other firms in cases like this is something that I've done for a number of years now. And it's important as lawyers that we understand the sensitive nature of this type of case. It's not an auto accident case. It's not like any other type of case. And we've taken sensitivity training. We've had experience representing survivors of sexual abuse. And certainly we're here to help in any way we can. So I'd like to start our slide presentation, if we could, Rob, and talk a little bit about the Child Victims Act. So the Child Victims Act of Maryland 2023 was passed by our legislature and signed into law by our governor. And it became effective October 1st of this year. And really what this law did, and a thank you should go out to Rob Jenner and many others who were at the forefront of getting this bill passed. It literally took them a decade or so to get this legislation through. And really thank you, Rob and others who supported the effort. There's something called the statute of limitations, and it applies in every state, and it's really a deadline for bringing a lawsuit. And previously in Maryland, the deadline for child sexual abuse was 18 plus 20 years. So in other words, you had until you were 38 years old to bring a case. And consequently, many people were not able to bring cases who would have otherwise had good cases. There's been research done that indicates that the average age where survivors really come to grips with child sexual abuse is 50 or 50 plus years old. And so it's clearly unfair and has been unfair to protect the perpetrators by virtue of the statute of limitations. So this law eliminates the statute of limitations altogether. So if, obviously, if you previously had a case but couldn't bring it because of the statute of limitations, you now can. Yeah, and if you're somebody who's over the age of 38 and you're a survivor of sexual abuse, childhood sexual abuse, the law now permits you to bring that case. But what's very important about this law is that the legislature recognized that it would get challenged from a constitutional perspective. So in the bill itself, there is something called a provision for an interlocutory appeal. And that's a fancy legal term, but what it really means is that this statute is going to go to our Supreme Court as early as possible for there to be a decision by the court as to whether or not the law is constitutional. If it's struck down, then I suspect the legislature will go back and try and fix it. If it's upheld, then all these cases that people have will be constitutional and meritorious and can be pursued. If we could go to the next slide. So one of the things that we wanted to make sure of, as you can see, our group is 3 law firms working together. We're not the only 3 law firms working on these childhood sexual abuse survivor claims. There are literally dozens of lawyers throughout the state and many lawyers from around the country who have descended on Maryland to work on these cases. So we thought it was very important that we establish a leadership group amongst the plaintiffs' bar so that we could all work together to put our best foot forward when it comes to the Child Victims Act and the ultimate appeal that is going to go to the Supreme Court of Maryland for a decision on constitutionality. So as a result of getting this leadership group established, the Jenner Law Firm, our law firm, and Grant and Eisenhofer, we got all the lawyers with the most cases, frankly, and we talked about really just picking a handful of cases to file in court. And we were not allowed to file till October 1st. So there are just a handful of cases now that have been filed, Montgomery County, Anne Arundel County, and a few other places. And what has happened, and we knew this would happen, and the bill even contemplates this, the defendants have filed motions to dismiss. And as a result of filing motions to dismiss, we have filed a response, and there's going to be oral argument in these trial courts in the coming months, and the trial courts will render a decision. The first decision that gets rendered and appealed to our Maryland Supreme Court will be really the landmark case for the Child Victims Act. And that's why all these plaintiffs groups are working together, sharing resources and their expertise. What will happen at the appellate court level is that the losing party will appeal to the Supreme Court. There will be briefing, just like there was at the trial court. There will be argument before the court, and then the Supreme Court of Maryland will issue a ruling on the constitutionality of the Child Victims Act. If we could go to the next slide. In addition to this constitutionality challenge, which is really a big part of where we are in the case, there's some other things you ought to know. The Child Victims Act only applies to survivors. So that if you have a relative or a friend who was a victim of childhood sexual abuse, if they're no longer alive, unfortunately, they do not have a case. So certainly people who are older or people who have health issues that are survivors, it would be advisable to try and pursue your case because your family and will not be able to provide or pursue, I should say, a claim if you're no longer with us. So another thing that's important to note is under the Child Victims Act, non-governmental defendants, schools, clergy, any non-governmental entity, the damages are capped at $1.5 million. And if it is a government, like a public school or some sort of camp that's run by a county or the like, those cases are capped at $890,000. Something that's very important to know, if you are a survivor of child sexual abuse under the age of 38, you've always had a claim, and you have a claim now. It doesn't matter what happens with the Child Victims Act or the constitutionality of the Child Victims Act. So if you are a survivor, the Child Victims Act does not apply to you. Likewise, you should know that the Child Victims Act applies to all survivors of sexual abuse, not just those who've been abused by clergy. As Rob alluded to before, any perpetrator, this act applies to any and all perpetrators, no matter who the abuser was. And one final thing I'll mention is that the Archdiocese of Baltimore, as most of you probably know, if you are a survivor from abuse related to the Archdiocese of Baltimore, they have elected certainly to file bankruptcy, and you're going to hear more from others about what we call the AOB cases. Rob, I think I've covered everything I was supposed to.
That's great. Thanks, Phil, for that background. Enormously useful and sets the table for the rest of us. Steve Kelly with Grant and Eisenhofer has committed his entire career to representing victims of crime and has a stellar record behind him. Let me ask you, Steve, where are we now with the Child Victims Act in terms of where we are in court, what cases have been filed, and what are the arguments that the plaintiffs that we're making to say that the act is constitutional, and what's the defendant's arguments as to why it's not?
Thank you, Rob. So as Phil mentioned, we and other plaintiffs' firms around the state filed strategic cases on October 1st with the end goal of getting the best case, the case to the Supreme Court in the quickest possible manner. And we also filed against various types of defendants, including the defendant that was the first really to file a substantial challenge, which was the Archdiocese of Washington, who is represented by one of the nation's premier law firms, Williams and Connolly, and one of the state's leading law firms. So this is a substantial challenge that was filed in two cases, a case of ours called Chappelle versus the Archdiocese of Washington et al. And then a case, and that case is pending in the Circuit Court for Montgomery County. In addition, the Archdiocese filed almost the identical motion the Archdiocese of Washington against in a case in Prince George's County involving a class action, which is known as John Doe versus Archdiocese of Washington, et cetera. So in both of these cases, it's essentially the same motion filed by, again, these preeminent lawyers. We have just received a third challenge in a federal case that we filed against a private school called the Key School. We filed a federal case and several cases in Anne Arundel County Circuit Court against the Key School based on widespread sexual abuse of students by teachers. And in the federal case, the Key School filed, again, nearly identical motion. So basically, we have three motions to dismiss that have been filed that are heavily coordinated by the defense. Fortunately, we, as Phil also mentioned, the plaintiffs' bar has really come together in Maryland, and really to support survivors and to make sure that we have the best and the brightest on our side, working together to craft the best possible challenge to the motions to dismiss to defend this law, which we think is long overdue. So as Phil mentioned, the opposition, the motions were filed, the oppositions have been filed, and then there will be one more brief called a reply brief that the defense gets to file. And after that, the courts will issue hearing dates and scheduling orders in terms of the hearing, and that the decisions will be rendered. And we can expect that no matter what happens, the cases are going to end up before the Maryland Supreme Court. So the main arguments that are the basis of this challenge are not really surprising. So as part of the 2017 Statute of Limitations Amendment, the church snuck a little present into the recesses of the bill and basically put in language in the bill that creates, or that basically suggests that the 2017 amendment to the statute of limitations is a thing called a statute of repose. Now, if you don't know what a statute of repose is, you'd be like most plaintiffs' lawyers in Maryland, or most lawyers in Maryland, because very few people know what this is. It's an obscure concept that applies very narrowly in certain circumstances. And so I'll explain what a statute of repose is in a second. But the argument is that because of this language that the church sort of snuck in there, that the rights not to be sued are what are called vested rights, and that it would be unconstitutional for the legislature to take away those vested rights. And so that the statute of repose can never be extended, essentially, is what the argument is constitutionally. So our response to that is a couple-fold. The first response is this thing, no matter what the church says about this obscure language, this is not a statute of repose. A statute of repose applies in one context in Maryland, essentially, and that's in the construction context. And the reason that a statute of repose was ever passed to begin with is because the legislature determined that there has to be a cutoff date for builders and architects and others in similar situations. When you're talking about constructing a building, there's got to be a cutoff date at which the builder or the architect are no longer responsible for design defects or other problems with the building. The responsibility shifts to the owner or someone who's responsible for the maintenance of a building. And the statute of repose is applied in this context, really, regardless of the injury. It doesn't matter when the injury occurs. The key date in the statute of repose is when did the construction take place? When were the architectural plans rendered? You know, it's when did the defendant do a certain act? And that act then triggers the statute of repose. So if it's a 20-year statute of repose, if the building was built in 1997, 20 years later, if someone was injured, there would be no claim. And it makes sense in the narrow context in which it's applied in Maryland. It makes no sense in the personal injury claim of a survivor of childhood sexual abuse. So the statute of limitations, which is what this law in 2017 is, it's what this law, the CVA, the Child Victims Act is. They're both statutes of limitations, which, as Phil talked about what that means, it's essentially a deadline that's triggered by an injury. And so if you look at the language of the statutes, the language of the 2017 statute, the language of the current statute, and what's called the legislative history, all the evidence that was presented to the legislators in 2017 and in support of the CVA, that all illustrates that what we're talking about is a statute of limitations, not a statute of repose. And there's really no dispute that the General Assembly has every right to change the statute of limitations. So if it is a statute of limitations, as we believe, then their argument fails.
So Steve, I think
yeah.
we'll have oral argument on this.
So the oral argument in terms of at the trial court level, we would anticipate, really within the next several months. And, as I said before, the court will then issue probably a written decision, the trial court, and that may take some time before the case is appealed to the Supreme Court, which will set out a whole nother schedule for briefing and then oral argument at the Supreme Court level. So that's why it takes such a long time, is because there's really a process that has to happen. And the only people who control that process are the judges. And
Go ahead. Sorry to interrupt. Go ahead.
No, that's right.
Let me move
So
on. Go ahead.
Go ahead. I was just going to say that the second argument is that even if this is a statute of repose, the statute of repose has been amended previously or extended in the case of asbestos in the 1990s. And both the Archdiocese of Baltimore and the Archdiocese of Washington supported that change when it was to their benefit. So when it was to their benefit to say that the statute of repose should be extended to allow the church to claim damages, then the church was all for it. But now that it's the church having to pay out damages, the church is against it. The only issue there is that this has never been challenged in court. And then, the last thing I'll say on this is a serious challenge. This is not a frivolous challenge. The lawyers on the other side are very, very good and very sharp. And these are not super cut and dried, easy issues. These are what we call novel issues. And so, there's a chance that the law could be held unconstitutional. We're doing everything we can to try to get that not to happen, but it's possible based on, the legal challenges that have been mounted.
All right. Well, thanks for that, Steve. Let me turn to Ray Fitch from Baird and Dallas. Ray has tried more cases than most, both on behalf of plaintiffs and also on the defense side in former days. Talk to us, Ray, about the appellate process. So Steve has already told us that the briefing is being submitted by both sides. The judge will submit an oral argument date, and then the trial court will issue a ruling, either granting the motion to dismiss or denying the motion to dismiss. What happens next?
Sure. So after the trial court issues an order either granting or denying, the side that is on the losing end will file an appeal to the Maryland appellate courts that will trigger what's called the appellate process. Maryland has two levels of appellate courts, the Appellate Court of Maryland and the Maryland Supreme Court. Typically what happens is a case is heard first in the Appellate Court of Maryland, and then the Maryland Supreme Court can decide whether or not it wants to take up the issue based on the ruling of the Intermediate Appellate Court. That could happen here. However, we strongly anticipate that this is an issue that the Maryland Supreme Court will take up immediately and likely skip over the intermediate appellate court briefing and deciding the issue preliminarily. So that is how that process will play out. It takes time. That the appellate court will issue a briefing schedule. So what was previously briefed and argued in the circuit court will be rebriefed and re-argued in front of the appellate court. And just like the circuit court issues an order, ultimately the Supreme Court of Maryland will issue an order, either determining that the CVA is constitutional or that the CVA is unconstitutional.
Is there another route to get to the Supreme Court through the federal court case that's filed on behalf of a survivor of the Key School?
There is. It's called a certified question of law in federal court. We have asked the federal court to certify the question of law on the issue of the constitutionality of the Child Victims Act. Again, we anticipate that's going to be opposed by the defense, but the federal court could certainly certify that specific issue, which is going to be addressed, mainly the constitutionality of the Child Victims Act, in which case the federal court would send that limited issue to the Maryland Supreme Court to decide that issue of state law, the constitutionality of the CVA under Maryland law.
Alicia Hawk, my law partner in Baltimore, let me ask you a question and follow up to that. If the Maryland Supreme Court comes and says that the law is constitutional, are all Child Victim Act claims barred?
You mean the law is unconstitutional?
Yes.
Only claims where the statute of limitation has expired. So, for example, if somebody is not yet 38, those claims will go forward. If somebody, as long as you fit within the current statute of limitations prior to the passing of the Child Victim Act, your claim will survive, even if the Child Victim Act is deemed to be unconstitutional.
So if the act is unconstitutional, we'll revert back to the law that existed before it was changed to the Child Victim Act, allowing people who are under the age of 38 to bring claims.
Correct.
All right, thanks for that information. Let me bring forward Gordon Avad from Grant and Eisenhofer. We are really fortunate to have on the Grant and Eisenhofer team one of the country's preeminent bankruptcy lawyers. And so we have had exceptional access to the bankruptcy court and the Archdiocese of Baltimore case that's filed there. Gordon has filed the first one of the first objections in that court on behalf of our three law firms, and stands up in front of the judge at every hearing and lets our position be known. Gordon, why don't you introduce people to bankruptcy court, what it is, and why we're there?
Sure. And thank you, Rob, and to all my other co-panelists. I appreciate everything that you've said thus far. I'm going to try to explain things in simple terms. Bankruptcy is complex, often confusing to people, and is foreign to many, as I would hope it is. And I'm sorry to have to be talking to you under these circumstances. But I specialize in this. I've been doing it for more than 20 years. And with our team of counsel here, we're able to really provide helpful advice and stand up, frankly, for the rights of survivors. And especially in this space, it proves important. So right on the eve of the opening of the statute window, the AOB, as we call it, but also the Roman Catholic Archbishop of Baltimore, filed for bankruptcy. And like other bankruptcies, this one is what's considered to be a reorganization, meaning the church is going to continue, It's just a question really of how the church deals with its survivors, and it pays out some sort of financial compensation and makes other changes to the ways that it conducts itself to allow it to rehabilitate itself using the bankruptcy code and the tools that are available to it. One of the things that we've been able to do is to participate and advocate on behalf of our clients, and to often counterbalance the church before the bankruptcy court. So bankruptcy 101, we're dealing with a single judge. She's responsible for everything that happens relative to the bankruptcy case. So right now, it's still rather early in the bankruptcy process. There has been a survivors committee appointed. That committee has its own counsel and is active in the case. And we are coordinating with them to ensure that we are all, if we were in a boat, we'd be rowing in the same direction, insofar as making sure that we and our opinions are heard and our concerns are heard on behalf of our clients. And so just generally, what does bankruptcy mean? Bankruptcy doesn't mean survivors get nothing. In fact, bankruptcy means survivors get something. We just don't know what that something is at the moment. And what it will depend on is really, what are the assets of the church? Meaning, what do they have that's available to satisfy claims of survivors? In addition, what can it get its hands on? So another way to think about it is, are there insurance policies that can be sources of cash that can be used to pay survivors? Does the church have real estate that it can sell? Does the church have the ability to go to its parishes and ask the parishes to basically help contribute to sponsor what will eventually become recoveries for survivors? So those are things that are all on the table. And it's part of an ordinary bankruptcy process where the first thing that happens is the business, or in this case, the church's handling of lawsuits or potential lawsuits against it, is stabilized, meaning there's a temporary stay. It's in bankruptcy, it's called the automatic stay, that prevented each of our clients from filing lawsuits on the first day because of the bankruptcy code's existence and the existence of the bankruptcy case. But that doesn't mean that survivors won't have their say. And this goes to a broader point, which is, I would say this to every survivor, whether you're a client of ours or not, and I'll speak to what we can do for our clients, but more broadly, your rights aren't lost because the company, or in this case, the church, has filed for bankruptcy. There's a process for filing claims. I'm going to talk about that in a minute. The best thing you can do is inform yourself. It's understanding that all the bankruptcy dockets are public. Bankruptcy documents are publicly available. There's a website. If you search Roman Catholic Archbishop of Baltimore bankruptcy claims agent, it'll come up. And you can have access to all the documents that are publicly filed in the bankruptcy case for free. And so I'll repeat that. It's a website. All you have to do is Google it. I don't have the website in front of me, so I can't give you the precise address. But if you search for Roman Catholic Archbishop of Baltimore claims agent website, you should be able to pull up that website and be able to view all the cases, all the documents that have been filed in the case. So you can look at, for example, the what's called the Statement of Financial Affairs and the Schedule of Assets and Liabilities. And you can have your own inside look as to what assets does the church have that could potentially be used to satisfy claims. You can also look at other examples of where there may be money available via insurance or otherwise. And so it's an interesting and useful tool that I think is important. Now, the most important thing here, above all, if you turn off, and this really only applies to those who are survivors of the church or have some affiliation with the church, rather than like the school that Steve spoke of before, but related to the AOB, Roman Catholic Archbishop of Baltimore, you want to focus on what's called the BAR date, BARDATE. It's a deadline that's going to be set. Now, we know from a hearing that occurred on December 18th that that deadline is going to be May 31, 2024. So we're talking 5 months or so, 5+ months out. There is time. But the most important thing you can do is either contact a lawyer, doesn't have to be us, it can be anybody who's a lawyer who knows something about these things, and ask questions. That deadline is unforgiving. If you miss the deadline, it's extremely hard to get a claim allowed after you miss the date. It just is. That's the way the law is. It's unfortunate that it's that way, but it is for a reason. Now, what does it mean to have a bar date? The bar date, in a way, because the church here filed for bankruptcy, negates the statute of limitations or the lack thereof under the state law. But from a practical perspective, the purpose of having a deadline or a bar date is to allow the church to know the known universe of survivors that have claims. They think they have an estimate, but they don't really know until they advertise the bar date, send out notices, make announcements in churches, put postings up in schools, and take other affirmative steps to help try to understand who may be a survivor so that survivors have a fair chance to come forward. Now, what does it mean to come forward? There's a basic 2 or 3 page form, which is called a proof of claim. Now, in this case, the judge has said, she hasn't entered her order yet, but at the hearing in December, she said, we're going to allow the proof of claim to be filed. And we're also going to suggest that a sexual abuse claim form, which is a questionnaire, also be submitted. Now, as I understood it, that's not going to be required, but it goes a long way to helping prove the existence of a claim to fill out that form. Now, I look at this like building a house. If you're going to submit a claim form, my suggestion is talk to an attorney before you start the process. So in other words, if we were a house builder, talk to somebody who can build a house when you lay the foundation, because that claim form down the road, maybe it's 6 months, maybe it's a year from now, could be subject to an objection. And it's better to have an attorney involved at the beginning to help guide you through the process rather than down the road after you've already had a claim objection that's been filed. But the claim form itself, I have a draft of it. I don't necessarily have the final version. So I would say stay tuned. But just so you know, it's going to ask a number of different questions. And so, for example, they're going to ask, there's a whole section, part 3, devoted to the nature of the abuse. And the form itself is going to ask really the who, when, where, not the why, you can't explain that, but the who, when, where, and what happened. Those are the basic questions. They're going to ask for detail and to be specific as possible, including this, for example, the name of the parish or school, if applicable, the name of the location. But it's a series of questions. Now, we're talking about a questionnaire that's maybe 5 or 6 pages long, but it is something which we would encourage you, and for our clients, we will be helping our clients fill out the form. And in a way, and I know that others may address this after me, but because we're representing a lot of different clients, we have sort of a centralized knowledge base. So, for example, when we're talking to our clients and doing intake and helping them fill out the form, they may not have the full name of somebody who might have been an abuser, but we may know that just because of our information and all the work that we did with our existing clients leading up to the deadline. So again, this is a pitch for not just us, but for all lawyers. Talk to a lawyer. Don't be intimidated by a bankruptcy claim form. The other important things, which I think are relevant, but there will be some degree of confidentiality with respect to these forms. These forms are going to be submitted to the bankruptcy court, and they'll be viewable by a handful of parties, including the church, including the insurance carriers, potentially including the parishes. But they will have, in essence, they will have different protections that can protect information and protect identities. And in these cases that involve survivors, the Roman Catholic Archbishop of Baltimore was really, I think, either the 36th or 37th church-related entity to file for bankruptcy. A lot of courts permit people to file proofs of claim with personally identifiable information in a redacted form. And so that would allow one to, Rob, go ahead. Let me just round it out for a second. But that allows you to really to take an intermediate step if you aren't really comfortable or prepared to fully be out in the public saying, yes, I've been abused, to make sure you preserve your legal rights so that you can receive compensation. Because without filing a proof of claim, there is no guarantee, and it would actually be the other way inverse. There is no assurance whatsoever that you will actually receive any compensation from the bankruptcy case. Now, Rob, go ahead. I'm sorry.
No, I didn't mean to cut you off. I just wanted to make it clear that when when a person reaches out to a lawyer to get assistance with the claim form, it's the law firm that is filing the claim form on behalf of the client. Is that right?
It can go either way. I've seen in cases where individuals can sign the claim form. Also, I've seen in cases where lawyers can sign it on behalf of their clients. So it really depends. But there are also two ways to file a claim form. You can either fill out the form the old-fashioned way and send it in the mail, or you can also submit it electronically. And so sometimes there are different procedures because again, the most important thing is to make sure that claim form is submitted and to get a receipt. So if I were when I file my taxes, I put the green card that, goes on anybody who files their taxes. No, but you send the card in and, they kick it back to you. It's your return receipt requested. There are ways to make sure that your claim form is actually received. And we're in a position where I would anticipate that just vis-a-vis our clients and our access to the church, we'll be able to, request confirmation from the church as to the receipt of our clients' proofs of claim, so that at least we have comfort and we make sure. And again, there are always fire drills, but I don't think anybody wants to wake up in the week of May 23rd, 2024 and say, I've got 7 days now to get this claim form in, and then have to go through the exhausting emotional part of filling this out and then have to worry about the mechanics of returning it. And so I would encourage all people, as soon as the final form becomes available, take a look at it, start thinking about those questions and issues. I think that's important. So again, May 31, 2024, super important. And then the other points I would just say about the bankruptcy process, and I don't want to belabor it, I want to make it as simple for folks as possible. But the bankruptcy process is not necessarily a short one. These cases sometimes will take 18 months. Sometimes they'll take 24 months. Sometimes they'll take 36 months. A lot of it depends on the temperature of the temperature of the church, the temperature of the survivors committee, and the insurance carriers. And when I say temperature, either you can fight, and what we do as lawyers, we litigate, which means we're fighting over things in court, or we can work consensually. And I think the next place that this ends up over the course of the next 3 to 6 months is directionally going to head to a mediation. And when I say that, it's not necessarily a mediation of any individual survivor's claim. It's more broad, thinking about the church and thinking about its assets and thinking about what a potential financial resolution could look like if the church and the parishes and the insurance carriers were to cobble together money and then approach the creditors committee, for example, which is made up of all survivors, but to try to cut a deal, which will then move through the bankruptcy process. And one of the things that we look forward to participating in, just because of the level of communication we've had with the creditors committee itself and with its members and its counsel, as well as with the debtor, on behalf of our clients, we're going to try to have a seat at the table as well. Just because at the end of the day, when looking at the bankruptcy process, individual creditors have their own rights to their own destiny as far as their claims, meaning that if a claim's objected to, it's up to the individual creditor and their counsel to oppose that objection. But on the other hand, the creditors all together are really working to try to, I like to say it's the form of pizza, right? If you're eating a pizza pie, you either have your individual pizza, your small pizza, your medium pizza, your large pizza, or maybe your extra large pizza, depending where you are in the country. And I'm not talking about Chicago deep dish or anything like that. But you want to try to make the pizza pie, what may appear to be a small or medium pie, into a larger pie. And the only way to do that is to really figure out, how can we marshal assets? How can we bring in assets and have as much money as possible to then divide up and distribute to survivors?
Right. So what we're looking at, Gordon, is looking at how much money is in their individual bank accounts, what sort of property they own, what sort of buildings they own, what sort of insurance proceeds may be available for particular years of abuse, and how much the parishes may have to chip in. So we're looking to get all that money and throw it into a single piggy bank or a single pizza, as you using your metaphor, to get as much money there as we can to distribute to the survivors. Is that right?
That's right. And the way the bankruptcy process is organized, you'll hear this term. It's called the plan of reorganization. And that's just a corporate document that describes a lot of different things. But one of those key elements is really what stuff is there that gets divided. And it also talks about how to divide it. So I know in the chat, we had a question about, well, what is an individual survivor going to get? We don't know yet what that looks like. We can tell you historically what some of the other cases have, but every case is really different because it depends on what the assets are of the church and how readily available those assets are for distribution to survivors. What I can tell you is that every effort is made by the Survivors Committee, which is the official group, plus our working group, to try to maximize the amount that's there. There are certain elements of pressure that can be exerted on the church. And there is also a counterbalance with really trying to do it so that we have distributions sooner rather than later. I like to say, as a lawyer for survivors, we want the best deal as soon as possible. We don't want the best deal that's going to take 10 years to get to, because that may not necessarily be the right deal for people that look at it. And then one important point as well that shouldn't be lost in any of this, there's the non-monetary component. A lot of survivors wish there to be changes within the church. And the bankruptcy court is a good way to do that, because that's ultimately, there has to be a bargain that's struck. There is a low likelihood that a bankruptcy court will force terms down on survivors without survivor consent. And when I say consent, it's not necessarily individual consent. It's more of, are there 2/3 in number who vote for something? So it's at a certain point, each individual survivor will be able to say, either I accept the plan or I reject the plan. And it's either thumbs up or thumbs down. And, the bankruptcy process itself is built to help drive consensus.
I think it's useful to let people know that, excuse me, the Survivors Committee now has a website. One of the attendees reminded us of that. It's www.baltimoresurvivors.com. I checked that website recently. It was not up as current as I would like it to be. The single most important point, as Gordon identified, is that May 31st of this year is the bar date claim. So it's the bar date. And so your claim form must be submitted by that date. I'm imploring people to contact a lawyer well before then, with apologies for the background.
Yeah, and Rob, one other point, and now I've taken the opportunity, if you do, and I told people to search Roman Catholic Archbishop of Baltimore claims agent. The name of the claims agent is EPIQ, EPIQ. The website is, it's sort of convoluted the way they do it now. It's no longer like simple www, but it's https://dm.epicEPIQ11.com/case/RCA Baltimore/info. And that takes you to the basic website. But even if you were to search Roman Catholic Archbishop of Baltimore and EPIQ EPIQ, it should take you to that website. And from there, there's case information. There's what's called the first day motions. There's the court's docket, and that has every document that's been filed in the case that's listed there. There's a section for claims. And, I'm looking at it right now. There's been a handful of claims that have been filed already. I think that's 4. And the way it lists here is Survivor 429 is how somebody's claim was filed. And then there are key documents as well. So I would encourage you to take some time, take a look around. And also, one thing that you can do, if any of you have any questions, you can always just reach out to me directly. My phone number is 646-722-8523. Again, 646-722-8523. I'm in New York. I'm not a Baltimore guy, unlike my partner, Steve, who is a Baltimore guy, and the rest of the folks here. But I'm available. And if you have questions, give me a call. I might take a little bit of time to get back to you, but I'll get back to you. And the worst I can do is to answer a question or two. The best we can do is to be able to, to help you out in any way needed. So I think of us as really as a resource.
Great, thanks, Gordon.
Okay, sure, Rob.
People are somehow and understandably, were upset when the bankruptcy proceedings were filed. And they were discouraged about it. Should they be? Is this the end of the day for them? And what's the difference between proceeding in bankruptcy and proceeding in civil court?
Yeah, so first, no, you should not be discouraged if you have been sort of forced to proceed in bankruptcy because of the Archdiocese of Baltimore's filing. But I do want to say not all survivors of childhood sexual abuse who wish to bring a claim are going to have to go through that bankruptcy process. The Archdiocese of Baltimore is the only bankruptcy in Maryland related to these claims right now. So there are other ways of bringing a lawsuit if you were not a survivor of the Catholic Church in Baltimore. And for example, if you were a survivor of the Archdiocese of Washington, there are actually multiple avenues. You can file an individual lawsuit, or there is a motion out there to certify a class. Now, there's not an actual class action for the Archdiocese of Washington, even though there's briefing in that there's been a motion to certify the class. What will happen next is a judge would have to agree, yes, this is the type of litigation that can be certified, and agree that there should be a class action. And if you have questions about that, you should contact an attorney. Our group here, we've not decided to go the class action route. We are filing individual cases in state court, even if it involves the Archdiocese of Washington. And sometimes it might have happened in Baltimore, but involving a defendant that's not covered by the bankruptcy, that wasn't insured by the Archbishop of Baltimore at the time. And so the difference in filing in proceeding through bankruptcy versus proceeding in a regular civil lawsuit, it's different, but it's also the same. For example, in bankruptcy, you have to put forth your claim form. The claim form basically sets out the who, what, where, when, why that you have a claim. And in a regular lawsuit, you put together your complaint, and the complaint sets out the who, what, where, when, why you have a claim, why your facts fit the element, we call them elements, of what you need to show in order to bring a lawsuit. So in that regard, it's the same whether you're in bankruptcy or in a civil suit. You're going to have a claim form or a complaint. And this judge in the Archdiocese of Baltimore's bankruptcy has been very clear that she wants people who want to have their story told. She wants to create an avenue for that. There are some people who are going to want to remain anonymous. And then there are some people who really, it's important for them to have their day in court. And this Judge Harner has been every single time she's had a hearing, she has reiterated, I want to carve out a way for people to have their story told. So for those who feel like their voice is being stamped out because of the bankruptcy, I'd like to say that I don't think that that's going to happen based on what this judge is telling us every single time we see her. We don't know exactly what it's going to look like, but there will be an opportunity in some way for your story to be told. So you'll have a claim in bankruptcy, you'll have a complaint in a civil lawsuit, and then a lot of the information that's going to come with sort of showing the value of those claims, whether in bankruptcy or in a civil lawsuit, happens in a lot of the same way, meaning your attorneys will help you gather information, and Kathy Kramer is going to speak about that in a little bit, but you go through a discovery process in a lawsuit where you gather your evidence. And you heard earlier about how our firms are collaborating for the motions and briefing the constitutionality issue. We're also collaborating in terms of defendants. So all of the law firms who are working on Child Victim Act cases in Maryland are working together to say, hey, if you have a case against this defendant, I do too, and gathering and working together to make sure we're really using our resources wisely against each of these cases or each of these defendants. So there's a process of gathering up your information that happens whether you're in bankruptcy or in a civil lawsuit. And then the real big difference is, at the end of the day, there's the mediation that will probably happen in bankruptcy. There's probably going to be a very similar mediation in an individual case, just on a much smaller scale. And then if you're not in bankruptcy and you don't reach a settlement through your mediation in a civil lawsuit, then there could potentially be a trial. And then a jury would decide the value of that case based on all the evidence that you gather. So you have a jury in the civil lawsuit, and then you have the mediation and all of the parties to that mediation working on that resolution in a bankruptcy. So while it seems like the bankruptcy is way different and you're having your voice stamped out, really, it's just a different way of getting at the same result.
So Alicia, so as I understand it then, there's really two tracks going on here right now. There's the bankruptcy track for those people who have claims against the Archdiocese of Baltimore and the parishes affiliated with the Archdiocese of Baltimore. And then there's a separate track in civil litigation in the court system where the constitutionality of the Child Victim Act is being challenged. Is that right?
That's right. And the constitutionality question, that's going to apply all across the board. It may very well apply to the bankruptcy. And in that case, being in bankruptcy might actually be a good thing, because the bankruptcy might proceed regardless of that ruling. We don't know. We don't know the answers to that. But yes, so there's the first hurdle. When you file your, earlier, Gordon mentioned that when you file a claim form in bankruptcy, there might be an objection to that down the road. Well, in a civil lawsuit, when you file your complaint, you get your objection right away, because the civil procedure rules require that if defendant is going to try and dismiss your case, they do it within a certain time frame right after filing. That's why we're briefing this constitutionality issue now, because they had a time frame when they had to challenge the complaint, and the way that they're challenging it is based on a legal issue, not based on any, factual issue of whether or not the abuse happened or how it happened.
So Alicia, looking in your crystal ball, so here we are, we're briefing the constitutionality right now. We have to go up to the intermediate appellate court at some level, then maybe hopefully it'll bounce right up to the Maryland Supreme Court. How much longer do you think we're looking at before we get a ruling from the Maryland Supreme Court?
So it depends. We have motions pending in Montgomery County. We have motions pending in Prince George's County. Those courts operate on their own time frame. So we don't know when we will get a hearing date in either one of those courts. We also have the motion to certify the question of law pending in federal court. There's an idea that, well, if it's in federal court and a federal court gets this motion to certify the question, it's going to happen quicker, and maybe we'll get to the Supreme Court faster. But at the end of the day, it depends on how quick the judge moves in any one of those dockets. So I think it's going to happen sometime in 2024. We'll have an answer to the question. I can't tell you how fast beyond that.
All right. So, Kathy Kramer, let's chat about what the rights and responsibilities are of a litigant in a Child Victims Act case. For those cases that you think will be going to trial, assuming that the act is constitutional, or for the sexual assault cases that don't rely on the Child Victims Act, what sort of participation is required by a client? In other words, do they have to give their name? Do they have to proceed in public? And what sort of obligations do they have moving through the legal system?
So in Maryland, you can proceed under a pseudonym. So you can proceed under Jane Doe or John Doe. So your identity wouldn't be known in the public sense. But one of the things that I always talk about the clients with when we do our initial intake and they're interested in pursuing the action as Jane Doe or John Doe, eventually the defendant, of course, is going to find out your identity because one of your obligations is going to be to answer discovery, these interrogatories that have information, questions about, not only similar to what Gordon described that are going to be on the claims forms for bankruptcy about what occurred and when, but also different impacts that it may have had and witnesses. So we will set up appointments after you perform your initial intake with one of us. We, as time goes on, we'll set up an appointment to gather additional information, potentially have meetings with an investigator depending upon the case. We're going to ask you to gather any evidence that you have in terms of yearbooks or notes or diaries from the time period. And those things are also going to be things that if you are a claimant under the bankruptcy that will be useful as well. You also would have an obligation if you were proceeding under the non-AOB track, the non-bankruptcy track, to sit for a deposition at some point. Now, you can see you have a very large team of attorneys here. We will prepare you for that deposition. We will be with you for the deposition. We'll be your advocates the whole time. So I know that the prospect sounds probably intimidating or frightening, but we will make sure that you are ready, you are prepared, that you got your team behind you for that deposition. And then Alicia did a really great job of describing what would happen with a mediation afterwards, similar to the claims process under the bankruptcy. There's an opportunity for a mediation to potentially resolve the case as a settlement without going to trial. But if that can't be done, then your case would go to trial and you would have to testify. Again, you'd have your legal team with you present. We would have experts who would testify on your behalf. So they are different tracks. There is more involvement potentially if the case proceeds through the trial track as opposed to the bankruptcy because of all the steps that I just discussed. But there are things that are similar about both. And I did see a question on there about, when are we going to be reaching out to you guys who are in the Archdiocese of Baltimore to begin the process of getting your claims form information. And we are doing that now. We should be able to contact all of you to initiate that process within the next month and a half to 2 months to get everything that we can with you and have ample time in advance of the May filing deadline to have everything that we can to file those claims. The one other thing I wanted to mention is if you're sitting here considering, should I hire an attorney? Should I not hire an attorney? I would say at least consult, because you may not know whether you have a bankruptcy claim under the Archdiocese of Baltimore or not. You may be thinking, well, it was this perpetrator at this church. And you may not know that there's actually a connection under the Archdiocese of Baltimore that would also bring the case into that. There would be a claim against them as well. And you just want to make sure that you're, consulting with people to determine whether or not your case, which track your case would proceed under, because you don't want to go about assuming that you've got all the time in the world and then find out later past May that actually you had some claims against the Archdiocese of Baltimore and that now it's too late. So, I would say consult with anyone. Doesn't have to be us, but consult with someone to find that out. And a lot of the firms that are working on this case, we have a lot of knowledge about different defendants, as Steve and Rob were explaining earlier, that may help you come to that determination.
Great. Thanks for that insight, Kathy. Just a reminder to folks, if you have a question, please go to the Q&A button at the bottom of your Zoom screen, type it in there and we'll get to it. I want to ask Mary Beth Diaz a question. Mary Beth is a paralegal who's in charge of basically all of us, and Mary Beth has literally spoken to hundreds of survivors over the past year and has been instrumental in giving guidance to people who eventually become clients or who just are asking for information. So let me just go right there, Mary Beth. I mean, when somebody calls and speaks with you about their potential claim, what do you tell them about what it's like working with a law firm and what their responsibilities are during the investigation period?
So first, I want to just say that survivors that make that phone call are extremely strong, and it takes a lot, and we understand that, and I certainly understand that. With regard to what I explain to potential clients is we take the burden of all of the quote unquote nonsense, the filling out of the form. While it can be done by an individual, you certainly, I think, need an attorney to represent you, to make sure that you are properly represented in the bankruptcy court or in the state court. It's important to take that off of you. You already are moving forward, bringing your story, telling your story, going through the re-traumatization of the events or event. And by having an attorney in your corner that knows exactly what needs to be done, when it needs to be done, what information is needed, we just take it off of your plate. And I think that that's most important for survivors.
All righty. What are the biggest concerns that you have heard about when survivors call?
So the biggest concern with survivors that I've spoken with are that they aren't heard. They are no longer able to have their quote day in court. And as Alicia explained, that's not the case. While you won't be standing in front of a jury of your peers, you certainly will have a voice, and that's not being taken away. It just may not be a vocal voice that a jury can hear and a judge can hear.
Mary Beth, just to address that as well, during one of the first two hearings in front of the bankruptcy court, I raised that issue for the judge, and the bankruptcy judge indicated her willingness to use her courtroom as a potential avenue to let victims, or I should say survivors, speak. And, it's not necessarily the same thing as speaking to a jury of your peers in the same way, but it is a way that survivors who feel able and are willing and interested in doing so, for them to be able to speak, at least with the presence of the church in the courtroom. And so that's a potential avenue. Naturally, the details haven't been worked out, but I think that's very much on the minds of survivors across the community of survivors, and will be something that folks push for.
That's awesome to know, because I didn't know that, and a lot of survivors are asking that question. So that's excellent.
So Gordon, since I have you, let me ask you a question. There's a question came in from an attendee saying, in essence, is the bankruptcy process going to be a waste of time if the law is ultimately determined to be unconstitutional?
Yeah, great question. And that's an ongoing subject of discussion. We've had a number of conversations with people involved in the case about that very question, and about whether the bankruptcy judge would decide to let's say, for example, the law was found to be unconstitutional. Would the bankruptcy judge let the church out of its own bankruptcy case? Because on one hand, the church sought the protection of the bankruptcy court because it felt the pressure of the impending opening of the statute. So it's not a clear-cut answer. But right now, this is the best avenue, and this is frankly the only avenue, is to play within the guidelines of where we are. And if that actually becomes an issue down the road, so be it. I think that there may be a push to try to get things done in the bankruptcy court before there's any final adjudication of those questions. But on the other hand, if I'm the insurance carriers, maybe I want to play it out a little bit longer to see what happens. So I wish I had a crystal ball and I could tell you. Unfortunately, I don't. But this is the process that we're in. And as evidenced by the fact that we're all on this call talking about it, a lot of people are invested in the process. And pursuing recoveries through the bankruptcy court rather than through the traditional civil litigation route.
Right.
And that, oh, sorry. And that again would reiterate why I think it's so important that you have representation, because there are so many different avenues that this can go down. And by having the proper legal representation, and not that saying that it has to be us, but we're in the thick of this. And obviously, you know, it's been proven by Gordon, who's given us all this information that we would have not been, you know, privy to if it wasn't for us being in the thick of this bankruptcy and what's taking place. And if you have representation, you're going to be properly represented, and the avenues aren't your issue. They're the attorney's job to, you know, work that through.
And remember what Phil said earlier on, if ultimately the Supreme Court comes back and says this is unconstitutional, would not prevent the legislature from going and trying again and reworking this bill, or even changing the Constitution, which is an avenue that has been considered. So the church would be right back in the bankruptcy court again. And there may be great value, and frankly, it's my opinion of others, there'd be great value for the church just to have this resolved once and for all, so it's not hanging over their head. I mean, the press on this, as everybody knows, is just horrific for the church, and they want to get this behind them. In my view, I think the bankruptcy is actually going to be protective of those people who have claims under the Child Victims Act. I think they're going to recover regardless of what the constitutionality is. That's my opinion, and you know, that's the way it's played out in another bankruptcy in Pennsylvania. But whether it plays out here, of course, you know, we don't know for certain. But there's a great chance that this may be the AOB people will be protected in the bankruptcy from any ruling on the constitutionality. Let me just, we're pressing a little bit for time, Steve Kelly, but I do want to get to some of the questions on criminal law. I know you've worked with criminal law in the past, representing crime victims. If somebody wants to file or bring charges against a perpetrator who's still alive, is that possible? And how do you even get that started?
Yeah. So the short answer is to report to law enforcement. They're in the jurisdiction which the abuse took place. So if it took place in the city, you would report to the Baltimore City Police Department. And there are various, all the jurisdictions have what are called child advocacy centers, who are usually, designated to take reports. And then, the decision as to whether or not to bring charges ultimately rests with the state's attorney's office. Each jurisdiction in Maryland has a state's attorney who's elected, and that person is the person who decides whether charges are to go forward or not. There is a process in Maryland where any citizen can go into the district court commissioner's office, and there are district court commissioners in every jurisdiction where there's a courthouse. And you can swear out an application for statement of charges. Basically where you just write down what happened, and then the commissioner will either issue a summons or a warrant. And that's a way to do it differently. The issue is that generally most states' attorneys will not bring those cases forward. So the best route is to go through law enforcement. And there's a great organization called the Maryland Crime Victim Resource Center, which has pro bono services, which can advise you all on how to go about this, what the risks and benefits are. Their number is 301-952-0063. Again, 301-952-0063.
Great. Thank you for that information, Steve. Does anybody have anything they want to add, or are there any other questions and answers that they want to bring?
I'll just say somebody asked a question about, when will the law firms be reaching out to us to gather our information for our claim form? And we already have. It starts with the first phone call to the firm and gathering that information. And you've seen emails. If you are represented by us, you've seen emails from us asking you to provide certain information. So we've been working behind the scenes on that claim form, and we will be setting up meetings with you.
Sounds right. Mary Beth, anything else you want to add in terms of communication with clients?
No, I would just say, make sure you're communicating with, if we do represent you, make sure you're communicating with us and keeping us up to date on phone numbers and addresses. Because again, as Alicia just said, we will be setting up these meetings with clients for these claim forms. But the other thing is to just make yourself as available as you possibly can, so that we can get what we need from you and you can get what you need from us. And make sure you vet whoever is calling you to make sure that you're giving information to the proper people, that it is someone from our team. We do have investigators that may reach out to you. Those investigators will vet themselves and let you know exactly who they are. And one of us will reach out to you prior to them contacting you. So just stay in communication with us and we'll try to do our best to keep you as updated as possible. If you are a client, we do have our client portal. And if you don't have access to that client portal, please email me or call me, and Maggie and I will make sure that you get access to that, but that is information there as well.
We provide a daily news update, so to speak, on our law firm webpage, jennerlawfirm.com. And we update it pretty much every day, every few days, with information involving AOB, the bankruptcy, or other Child Victim Act matters that are appropriate for people who are contemplating bringing claims. Sometimes we talk about what's going on, what's being written by the Baltimore Sun or what's being written by the Baltimore Banner. C.T. Wilson was just given Baltimore Sun Marylander of the Year, which was he was the delegate who brought the Child Victims Act. So obviously there's a lot of notoriety going along even through the end of the year with the Child Victims Act. So on behalf of Baird, Mondelez, Broxton, and Federico, and Grant and Eisenhofer and Jenner Law, we appreciate those folks who took the time to listen. We hope we provided the information that you need to get some of your questions answered. And if not, certainly reach out to us. You can email us at info@jennerlawfirm.com. If you want to send us an email or give us a call at 410-413-2155, we'll be glad to answer your questions personally. Again, thank you for attending, and we look forward to seeing you perhaps at our next virtual town hall meeting. Thanks again, and good evening, everyone.